Sarah Medina. I'm a member of the board of SPI. It's a consulting company that we are in charge of coordinating this ENRICH in China. And I'm very pleased to be here with you today to have this webinar about how to manage IPR in China. So we are going to have a very selective group of speakers from different types of organizations, including Jessie Zhang from Eurelations, Aida Balbuena-Diez from the IPR SME Helpdesk in China, and Huang from the School of Management of Zhejiang University. Just a few words about ENRICH in China. ENRICH in China is a new initiative from the European Commission to establish a center based in China to help Europeans on all the research and innovation topics in China. So we are providing different types of services, and Jessie Zhang will present you the types of services that ENRICH in China is already able to offer to all of you in China. So we offer these services to researchers, to SMEs, to startups, universities, companies, to different types of organizations that have an interest on research and innovation activities in China. The center was officially launched in Beijing in October of 2017. So it's established within the EU SME Center in Beijing, and we already have a regional hub established in Chengdu. Today, in this webinar, we have more than 100 participants that registered for this webinar from 25 EU member states. We also have with us members of the advisory board and also representatives from the European Commission, including Diego Samaritano, the policy officer for cooperation with China, and Laurent Boschereau, the head of science, technology, and environment from the EU delegation in China. Of course, this work would not be possible without all the support from all the partners of ENRICH in China. I'd like particularly to thank FFG, the National Funding Agency from Austria, to Eli Stepanovic for all her support, together with Jessie Zhang from the project manager of Eurelations based in Switzerland for all the support, and also all the staff from SPI. I'd like also to thank the speakers to have agreed to be with us, and all of you to be able to join us in this webinar. Also, the consortium, apart from SPI, has partners from different organizations, including from Europe and also from China. So again, welcome to this webinar. This is the second webinar of ENRICH in China, and we are going to have more webinars coming up in the next months. So stay tuned also for coming up of new activities and new services of ENRICH in China. So I'd like now to welcome Jessie Zhang. Jessie Zhang, she's a project manager at Eurelations. She's one of the partners of the project, and she will tell us about the services of ENRICH in China and how you can be connected on research and innovation and how we are able to support all your needs. Welcome, Jessie, please.
Thank you, Sarah. Good morning, everyone in Europe, and good afternoon, everyone in China. Welcome to my presentation today about the ENRICH. ENRICH is the European network of research and innovation centers and hubs in China. As Sarah already mentioned, I work at Eurelations. We are based in Switzerland. So how does it work? This ENRICH is a global initiative to internationalize European research and innovations. It is promoted by the European Commission through Horizon 2020, and it is a network of centers and hubs that promote European STI internationally. ENRICH has already been established in Brazil, China, and USA. And how does ENRICH in China work? We connect and support European STI organizations in China by providing services. We reinforce the leadership of European STI in China, and we promote STI cooperation between Europe and China. So, yeah, who do we serve? Who are the ENRICH clients? We are having three different groups. The first one is the research actors, which are universities, research organizations, and then the second group is the innovation actors. And the third group is the business actors. And here you can see some details about these actors. Yes, the research actors are the universities, research centers, and the research councils. And the innovation actors are innovation agencies, funding agencies, STI networks, and platforms. And the third group are companies, startups, SMEs, and etc. ENRICH has been already established strategically in different locations. The headquarters of ENRICH is hosted by EU SME Center in Beijing. It's been open since November last year. And ENRICH has an liaison office in Brussels, which is hosted by EBM. And as Sarah already mentioned, the first regional hub of ENRICH has been opened in also last year in Chengdu, and it is hosted by UPIC in its new infrastructure business and innovation center for China-Europe cooperation. And more regional hubs will be opened in China in the future. Here you can see some pictures. You can have some impressions of our launch ceremony last year in Beijing and in Chengdu when we opened our headquarters in Beijing and the first regional hub in Chengdu. And along with the launch ceremony, ENRICH organized a matchmaking tour in China. So in October, we organized the matchmaking tour along with the launch ceremonies, and more than 50 representatives from 20 member states joined this tour, and they went to visit Chengdu, Beijing, and Qingdao. Now I would like to talk a little bit about the service portfolio. ENRICH offers 7 categories of services. The first category is the RDI consultancy and coaching. RDI stands for research development and innovation. Here we offer customized consultancy and coaching. And the second category is the STI RDI intelligence. Here we offer different studies and analysis, such as feasibility studies, foresight analysis, business plans, and also strategic partner searching, etc. And the third category is the soft landing and co-working service. And here we offer the European organization. We offer them localization guidance, co-working space, and administrative and the secretariat support. And we also offer guidance and support in laws and regulations, and also the introduction to the local scientific and business community. The fourth category is the fostering open innovation through trainings, such as this webinar is one of the trainings we offer. And beside the webinar, we also offer, of course, we also offer physical trainings, such as workshops and short courses. And the fifth group of service is cooperation enabling events. We offer matchmaking sessions, roadshows, business visits, scientific exchanges, seminars, and conferences. And the sixth group of the category is the RDI briefings. Here we will give you the latest development in Chinese SDI landscape, also give you examples of, give you information about the existing STI funding opportunities, as well as the success stories of STI collaborations between Europe and China. And the seventh category of service we offer is the innovation support certification. And how does this certification work? Here, if you are interested to become a certified ENRICH innovation support organization, you need to fulfill first a detailed questionnaire and followed by an on-site audit. And if your organization meets the threshold, you will obtain the certification. And later on, there will be annual audit in order to ensure the certified organization continues to meet the established threshold. And based on this service, we now opened a call for interest for soft landing zones. So if your organization is a European or a Chinese business support organization, which are based in China and which are willing to help European companies and researchers to operate in Chinese market, then you should definitively join the ENRICH community and become one of the 30 certified ENRICH soft landing zones. And more details you can find out on our website. And important is to apply it. The deadline is on the 28th of March, and you can download and complete the certification questionnaire on our website and send it back to china@enrichcenters.eu. And ENRICH has been offering services since end of last year. We organized and supported 1.5 days of activities for the Agency for Science, Innovation and Technology of Lithuania. And these activities included trainings by experts from the EU SME Center, IPR Helpdesk, and business visits and B2B meetings. And we also offered our first webinar. Some of you have already participated. There was also end of last year, 75 people from 18 different EU member states joined our last webinar. And we also organized this year already our first business and innovation networking breakfast in Beijing. And the participants discussed the current economic growth in China, as well as the incubation and acceleration opportunities for EU startups in China. And there will be more trainings and events upcoming. Here, I would like to give you a short overview of the activities we planned for the first half of the year. There will be more trainings. So in March 15th, we plan to have our next webinar, and it's on the topic EU-China R&I collaboration from the European perspective. And in April, there will be another webinar on the same topic, but from the Chinese perspective. And the first short course will be offered in Europe in April on the topic Innovative Business Acceleration in China. And the location will be announced later. And also in May, we are going to have a workshop in Chengdu about Horizon 2020 on the Europe Day in China. And also in May, we are going to offer another webinar on the Horizon 2020 and Chinese co-founding mechanism. And in June, there will be a short course also in Europe on the topic Knowledge and Technology Transfer to China. And in June, there will be also another webinar on open and responsible research and innovation in China. So as I said, webinars are of course offered online, but all the other short courses and workshops will be offered physically. So if your organization is interested to host one of our trainings, please do not hesitate to contact us, and we will be very glad to get to know you and to see how we can work together. And there are also other events besides the trainings, such as in May, we'll be in Beijing, the scientific exchange initiative, and in Chengdu, there will be also a China Business and Innovation Networking Breakfast. And in June, we are going to organize a roadshow on making business in China. So stay tuned, and we look forward to seeing you on our upcoming activities. And so thank you for your attention.
Thank you very much, Jessie, for the very good overview of ENRICH in China and what we can offer to all of you, basically all the participants in this webinar, and all the researchers, all the companies, and all different types of organizations that have an interest on research and the innovation activities in the China market. So for any question, you feel free to post now. You can start posting your questions under the platform so that we can respond to them during the discussion session. And if you have also more questions afterwards, you can always contact us by email or by telephone. We'll pass now to Huang. Huang, if you could now start, please, because the other panelist is still connecting to the system. It's having some issues on connecting from China. So I'd like to present you Huang, Professor Huang from the School of Management, Zhejiang University. He's the head of Department of Innovation, Entrepreneurship and Strategy and co-director of the Institute for Intellectual Property Management from the School of Management in Zhejiang University, and he's also advisory board of ENRICH in China. Professor Huang has a large experience in working with the Europeans, and he has spent a number of years in Europe, both in Portugal, where he did his PhD, and then he worked for Merit in Merit Institute in the Netherlands. So I'm very, very pleased to introduce you, Professor Huang. Welcome.
Okay, thank you, Sarah. So I hope you can hear me. So and the connection will be, be good and smooth in the next 20 minutes when I present. Hello everybody. So I'm glad to and honor to give a presentation in this webinar about the recent trends on Chinese IPR system. So if we can move on next slide. Okay, so my talk will be divided into 3 parts. So first I will introduce you briefly that China has a young intellectual property rights system. And then I will discuss why the country now is so much emphasize so much on the innovation-driven development strategy and how the IPR play a role in this overall strategy. And then the last part, I will discuss about the recent progress on legislation in China with regard to the IPR. So basically, China has a relatively young intellectual property rights system compared with Western countries. So the primitive type of the IP or the patent system already exists in Europe in the 14th century, so in Venice. And the major invention in the Industrial Revolution were patented in the UK, and patents and IP was in the US Constitution in 1918. 1889. But China in the modern time only have 30 years of history of using IP. So the major law actually were promulgated in 1980s. You can see the trademark law, patent law, copyright law, and so on was promulgated kind of rather recently. So if we move to the next slide. But the difference of the Chinese IPR system is that although it's relatively young, but it's move relatively also fast. So in the 30 years history, China already amended this patent law 3 times. For the other country, maybe amend a law once a decade or once in 20 years, but China amended the law every 10 years at least. And now it's discussion about the 4th Amendment of patent law. The latest draft was published in 2015. In all of this amendment of patent law, the overall trend is strengthening patent protection. So you can see that every time the amendment law, the protection was become more strict and better enforced. So we can move to the next slide. So in terms of I will have small slides later on discussing about the latest amendment, the 4th Amendment. But here we can describe you some general trends in terms of the IP activities in China. First of all, China in 2011 already overtake United States, become the country in the world to receive most invention patent applications. So here in the slides, there were 5 major offices in the world, patent office in the world, in terms of the volume. So the USPTO, European Patent Office, Japanese Patent Office, and Korean Patent Office. Together with China, we call IP5. So you can see China already become the country in the world receive most of patent application, but still the growth speed is still at about 20% annually. So in the last year, so in 2017, the growth rate is about 15%. So even today is number 1 in the world in terms of the number of the invention patent application. China still goes at a relative rapid speed. Next slide. So in terms of the 3 types of patents that entities can apply for in China, we show here the numbers. So in China, we can apply for invention patents, which is regular patents you can apply in any other countries. In China, you also can apply for utility model, which is to protect the incremental innovation. Utility model exists in about 80 countries in the world. In Europe, at least in Germany, Spain, there were this type of patents. I think also in UK. In China, it is protected for shorter period compared with invention patents. It's only protected for 10 years. It doesn't need to go through substantive examination, which means that applicants, you apply for the utility model, as long as the format is correct, you have no examiners look at your content very carefully. There's no substantive examination there. You get it quicker and cheaper. So you can see utility model, the number is also huge, almost as many as invention patents. And the design rights in China can be protected as a patents, what they call design patents. So this is a basic 3 types patents you can apply for in China. Next slide. So the next slide shows us the comparison between the domestic entities, the domestic companies, universities, research institutes, or individuals, and with foreign entities, how they apply for different type of patents. You can see that the overall domestic entities apply for more patents than the foreign entities. And the change and the gap between the domestic entities and foreign entities become larger ever. But if you look at a utility model, you can see this type of patents are mostly applied for by domestic entities. The foreign entities apply for very few utility models. So the utility model line for foreign entities is almost near zero line. And that's posed some interesting question for the foreign entities, either university, either companies, why they don't use utility model. There were studies looking at the issues. One explanation is that the IP councils working in the foreign companies or act as intermediary for foreign organizations, they are trained in Western countries. They are not so familiar with utility model type of patents. So when they come into China, they feel that this type of patent, because they have not gone through the substantive examination, the quality is doubtful, and the protection period is also shorter than compared with invention patents. They're not willing to seek for protection of this type of patents. But the Chinese entities, they use a lot. So, but in terms of the legal rights or the validity of the patent rights, both are almost equal. So it's equally difficult to invalidate utility model as compared with invention patents. So this poses some challenge for foreign companies, foreign entities, because they're competing with Chinese firms, but Chinese firms apply for utility model, it's cheaper, quicker, is as equally difficult to invalidate compared with the invention patents. But a foreign company, they don't use this type of patents. So this is a symmetry in competition, and it's an interesting question to look at it and to analyze. So next slide. So when we look at the international filing, so the previous 3 slides are all about domestic filing, so the patents filed in China. But we look at the Chinese filings from China to the world, to other offices. We can see now China also pick up very rapidly in terms of the filing through the PCT route, which is there's a patent cooperation treaty allow that company in the world to file patent application abroad using the priority. But this treaty is administered by the World Intellectual Property Organization in Switzerland. And there they present the statistics about the international filing through the PCT, what they call PCT routes. So here you can see US, Japan, they have largest number of the international patent filings through PCT routes. But China already now become the 3rd country in the world in terms of number of PCT filings. Please remember, the international filing of patent is very expensive. So a company can easily spend 200,000 euros for each piece of these PCT filings. If you seek protection in the US, Europe, Japan, plus China, maybe India and Mexico, you can easily spend 200,000 US dollars for each piece. A patent family in these 5 or 6 countries and regions. So then China has already a large number, and it also increased very rapidly. So it's meaning that Chinese companies are also expanding abroad and seeking patent protection in overseas markets. Next slide. So the next slide is about discussing why there are so many patent filings in China and why they grow so rapidly. So there were studies looking at the reasons. One reason is that China joining WTO, and China amend the patent law. The second amendment is to make the Chinese patent law in line with the TRIPS agreement in WTO. So there were multinational companies seeing China is more in line with international practice, so they increased their filings. Also, the Chinese industry has intensified their R&D activities, so there are more R&D, more innovation. They can file more patents. So foreign firms also increase their investments in China. They have to increase their filings to protect their innovation in China. And also, every time, as I said, China amend the patent law, it strengthens protection. So then, which means that the value of the patents, entities, foreign company they have in China, with the amendment, every time the value go up because of they become better protected. They can better enforce their rights in the market. So the value of the rights increasing, so that then the companies are willing to have more rights. And also the deepening of enterprises reform in China in the last 20 or 30 years. Previously, a lot of companies that were collective owned, they were state owned, there were relaxed supervision of the asset of the company, but now many of them are privatized in the last 20 years. So the private owners, they're more care about it. The value of the assets, they are more actively enforce their rights. So they file more patent applications. The last point is about the government subsidy, which is a little bit unique in China, but as far as I know, there's in Europe, in Sweden, for example, also governments give subsidy to small and medium-sized company to subsidize their filings. So next slide. So next slide is discuss about this patent subsidy. It's a little bit unique in China. It was run by the provincial governments, but it's not by central governments. Although central governments also provide some subsidy for the international filing, but most of the subsidy for filings are given by the provincial governments. So these filings, they subsidize filing fee, also renewal fee. They don't discriminate domestic firms or foreign firms. The foreign firms, as far as I know, they also can have some subsidies. They encourage inventors patent abroad. So as you can see from the table, so the first province or first city rolling out a subsidy program is Shanghai. It's about almost 20 years ago. Then followed suit by other provinces. But the trend is not apt. So now these subsidies are still on. So if foreign company, a domestic company in China today still can apply for subsidy from provincial governments. Okay, next slide. So please, next slide. So next slide, I will discuss about a second issue about the role of IP policy played in today's China, as the country is determined to build an innovation-driven economy. And the background of why IPs become so important now in China, why the top political leaders, either President Xi Jinping or Premier Li Keqiang, in most of occasions, every time they meet the foreign counterparts discussing about innovation, they would emphasize that China needs very stringent IP protection. Next slide. The background is that, as we can see from these slides, in the last half a century, there's only a handful of countries be able to move out of the what I call middle income trap to become a high income country. So from the left figure in these slides, you can see only in Japan and Korea, South Korea, be able to move out of the middle income trap. From the right figure, you can see that this every dot represented one country in the world, and the horizontal axis shows that in 1960s, these countries' GDP per capita versus United States GDP per capita, and the axis, or you can say vertical axis, is about in 2008, after 48 years, how this country stands versus United States. You can see that all in the blue dots, they are the economies or countries were able to improve their development status versus United States, able to close the gap with United States. So most of the countries stuck in the middle, what we call middle income trap. So they're not able to improve their GDP per capita versus US. So China are still in the middle kind of quadrant, and China in 2012 in this 18th Party's National Congress of Chinese Communist Party rolled out a innovation-driven development strategy to further develop the economy and social society through innovation-driven strategy. And IP plays a central role in this strategy. Next slide. So the central challenge for implementing this development strategy also move up the value, move China out of the middle income trap, is to have the country have the more high value added activities, to have more higher value added industries. So as almost everybody knows that most of the Apple's products are produced in mainland China by a Taiwanese company, Foxconn. But Foxconn employ around 1 million employees in China. A lot of them are the workers. They produce almost every Apple's products, but the value they capture in mainland China as a form of the worker salary is very small in the whole pie of the Apple's value chain, products value chain. So most of the profit goes to Apple, and the Korean, Japanese component manufacturers capture some of them because they provide screens, they provide components like sound components or communication components. But although there were thousands of hundreds of thousands of workers assembly this iPhone, iPad in mainland China's factories, but they only capture 1.8% of the value of the whole products. So that's what China wants to improve. So if a lot of people working on these low value activities, it's very difficult for the countries to move out of that middle income trap, because of the GDP per capita will be very low. But I think any country wants to move into the high value added activities. But then these activities, these industries, niche market, they are highly protected by IP. And Chinese companies are not good at this because that were not their competitive advantage in the last 20 years or 30 years. Now they need to learn the game, play by this rule, not only in China, but also when they expand overseas markets. So now IP become a one important topic in the innovation policy setting in China, also making in China. And in many occasions, you can hear the talking and the policy discussion is all about strength on IP protection. So how to help Chinese company to move out of value chain, how to help them to better manage the IP assets and to compete in international markets. Next slide.
Hello, Professor Huang. Can you hear us? Could
Yes.
you continue, please?
Yeah.
We stop
Can
listening.
you move to next slide? One more. One more. Next slide. Okay. So the last part is about the recent legislation progress in Chinese IPR system. The first one I want to introduce, the Fourth Amendment of Patent Law, is still under discussion, but this process has been for 6 years already. So the problem with the Third Amendment, the current patent law, is that the patent law pretty much has the problem of the difficulty in collecting infringement evidence. There were long legal and administrative procedures, low awarded damages, high cost, and low effective enforcement. So this quotation is official quotation. It's a judgment from the Chinese government. So it's official judgment about the current problem of the Chinese patent law. And among these problems, the core one is low awarded damage. And the whole system is very much award the quantity over quality. And the policymaker in China realize this, and they want to increase the quality of the patents. But as a coherent actions, they put this idea to emphasize quality in the Fourth Amendment. Next slide. So this is, as I said, this is a 6 years process already. So the first draft has been circulated in 2011. So now we are in 2018. I heard that last year it should pass last year, but it will not pass last year. So the last draft we had is announced already end of 2015. So next slide. So in this Fourth Amendment, the draft circulated in end of 2015, as I said, the one important change, there were 5 aspects of important change, but one aspect of important change is to increase the protection, increase protection. So there are several measures to increase protection. First of all, what is called burden of proof reversal. So let me explain what is mean. This is a bit of legal term. So in the Chinese current patent law, the principle of the patent law in terms of the presenting proof to the court is in line with the civil law principle, which means that who litigate should present the evidence. In a patent infringement case, who litigate is the company, for example, have the patents, own the patents, owner. And then the defendant is would be the infringer. So the plaintiff, they sue the defendants. They need to present to the court evidence how much damage the infringer make to the patent owner. But because of the company, the plaintiff is not pleased. He cannot see the book of the defendant. So then, in most of cases, they cannot present convincing evidence to the court how many copies the infringer has sold the products infringing the technologies. And then the court only can award what they call statutory damage, which is rather low. And because the evidence is very difficult to collect and present, and this actually make the very little protection for the IP rights. So in the proposed amendment of the law, it introduced the called burden of proof reversal, which means that if the judge thinks the defendant infringed the plaintiff's rights, patent rights, he will order the burden of the presenting the proof shifting from the plaintiff to defendants. So the defendants who are the infringer has to present to the court how many copies it sold, infringing technologies. If he cannot present, if he doesn't want to present, the judge can give a punitive damage, which is my second point here in the slides. So previous there was no punitive damage. So the defendants only need to pay for the plaintiff about how many copies they sold, the exact damage they make to the plaintiff. But in the amendment of the law, it proposed that the judge can award damage up to 3 times of the loss of plaintiff. Right? This gives the punishment to the infringers, and also increase the statutory damage from the current range of the 10,000 RMB to 1 million to a range of the 100,000 to 5 million. So significantly increase the amount of damage, statutory damage that the court can award. So these are 3 measures just to strengthen patent protection if the law passes as it is. Okay, next slide. Next slide. Okay, another important legal progress. Previous one, please. Yeah, this one is an important law, amendment of a law, what they call law on promoting the transformation on scientific and technological achievements. It was passed in 2016 and became effective in October 1st, 2016. And this is an important law to regulating technology transfer from Chinese universities and public research organizations to company. And before the law was amended, there were serious barriers for technology transfer from Chinese universities, public research organizations to company. And first of all, before the law was amended, the authority regulating technology transfer issues are not totally with universities. The universities or PRO, the public research organizations, has to seek approval from government agencies to approve for example, the patent sales. And because of according to the law, the university professors or researchers that make inventions, but the right of the patents on that invention belong to university, the core service invention. So because of the patents are owned by universities, it considered as a state-owned asset. The state-owned asset in China is a very sensitive term. So which means that anything about the transfer of the state-owned assets has to seek approval from government agencies. There are legal risk if you don't get a price right. And also, before the law was amended, the university or PRO has to give their profit from the transfer to the government agencies. They cannot keep that the profits, the revenue. And also, there are impediments for university researchers to start their companies on also public listing. Next slide. So after law was amended in 2016, this barrier was cleared. First of all, in the law, it says that the revenue from technology transfer can be returned by universities and PRO. No approval from transfer from government is needed. In the law, it stipulates that no less than 20% of revenue from the technology transfer should be given to inventors as compensation. In Stanford University, as far as I know, the revenue from the technology transfer, 1/3 goes to the university, 1/3 goes to the school or institute, and 1/3 goes to the inventor, the professors team. So in Chinese law, they say no less than 20% should go to the inventor team. But in many Chinese universities, after law was amended, they make its own rule saying that no less than 70%. 70% of the revenue of the technology transfer goes to the inventor teams, including my university, Zhejiang University, including Tsinghua and many other Chinese universities. So now we say that in China, Chinese professors get a better deal than Stanford University to get a 70% of revenue from the transfer. And one more is that the price negotiation before the law was amended wasn't allowed. Now it's allowed. So the university and the company can negotiate a price as far as they publish the price later to the general public. And also the researchers' part-time employment and temporary leave from the university to start up their own company are allowed now.
Thank you very much, Professor Huang, for the very good overview of the recent trends on the Chinese IPR system. Thank you so much once again. Now it's my pleasure to introduce you Aida Balbuena-Diez. She's the project officer, China IPR SME Helpdesk, and she will tell us about protection in China in a nutshell. And the IPR Helpdesk is already established in Beijing for a long time, and they provide support also for European organizations on IPR issues in China. And ENRICH in China is very pleased to be cooperating with the IPR Helpdesk. So welcome, Aida.
Good morning, everyone. Sorry for the change of schedule. I'm Aida. I'll be discussing a little bit with you today how to protect your IPR in China. Please pass to the next slide. Our project was launched in 2008 with EU funding, and we've been providing since USMEs with free and confidential advice on IPR protection and enforcement. Our motto is know before you go, and today we'll be knowing a little bit before going. Please go to the next slide. So a little bit of an overview of our services are the inquiry hotline, which is our main form of helping SMEs. You can contact us via email, website, or telephone, or even WeChat, and we will answer your question within 3 working days, no matter how difficult the question is. We have the website and the blog that you can check out, and you will see news regarding legislation and cases, plus articles, training workshops, and live webinars like today. We have communication, and even a game to check how your business would do right now in China in terms of let's start now to break down the main IPRs with trademarks. This is the most common IP issue that EU SMEs face in China. They are always asking how to register what is a trademark even. So let's see a little bit what is what in China. What can be registered as a trademark? Well, you can register a sign. So this includes words or a slogan like just do it or impossible is nothing. Then we have the logos, like the Apple logo, color combination, numbers, sounds, 3D symbols, which is actually my favorite, one of my favorite cases. Ferrero Rocher, the bonbon maker has registered their shape, so no one can do the same shape because they were copying it and selling it as it was theirs. And very important to know, you cannot trademark something that identifies the source of the product or the service, so you cannot be called the restaurant and then trademark this the restaurant. Next slide. very, very, very important to know in China is that China is a first-to-file system, and it means that you need to be the one to register your trademark in order to have it, because the one that registers first gets it. There are two types of registration. They both have their pros and cons. One is the Madrid Protocol. With that, you can register all over the world, basically, but you can't register your Chinese character name for your trademark. That would be needed to be registered with the China Trademark Office. And it has nearly like a little different system than the Madrid Protocol in what classes and subclasses mean. So when you come to China, if you choose to register through the China Trademark Office, you will need to be very aware that, let's say you're a dairy company and you want to register your name, you need to register for all the subclasses. So you cannot register for dairy, you need to register for milk, yogurt, cheese, anything that you would like to register in dairy under that category, or otherwise you will not be covered in that category. A very good example of this was that quite well-known fashion label register everything except for wedding dresses, and someone started using their name for wedding dresses, and this was perfectly illegal because it wasn't registered to that name. Also important to know is that you will be required to have a trademark agent if you choose to register in China if you do not have a Chinese address. So this is very important to take in mind regarding trademarks, and if you have any specific questions to your SME, again, we provide confidential and free advice, so just contact us and we can help you with your problem specifically. Next slide, please. We're going to discuss now patents. There are three types of patents in China. Invention patent that covers you for 20 years, utility model patent that covers you for 10 years, and design patent that covers you for 10 years as well. In China, designs are protected as a patent, unlike the EU, where they are protected as a registered community design. This is a good thing to know. You really need to use a very experienced patent attorney or agent, since a patent is a very technical IP right. And also you need to have a very accurate translation, because otherwise the scope of protection might not be the correct one. The absolute requirement of novelty in China is a very Chinese-specific requirement, and it means that the invention that you are trying to patent or the design that you are trying to patent cannot have been made public anywhere in the world, or the patent can be found to be invalid. We've seen many examples in China of cases where they have, for example, come out with a car, and that car shape was registered as a design, and then 2 days later, the copycats having the same shape of, let's say, a Range Rover in the streets of Beijing, and that's okay because it's not registered. So it's a very, very important thing to keep in mind. Next slide, please. Graphical user interfaces can also be protected under design patents, but you should apply for it together with the product. Next slide, please. Now, watch out. Watch out for the difference with the EU. In China, no registration equals no protection in what the trademark and patents is referred. In the EU, a registered design can still be protected for a while. If it's not registered, it's 3 years. If it's registered, it's 25. But this is not the case in China, as mentioned before, with the novelty requirement. So the biggest lesson here is just keep it secret, keep it protected, sign NDAs, do what you need to do for it not to be public knowledge in order to protect your rights. Next slide, please. We're going to talk about copyright now. Copyright is, you can protect your design. So copyright if it's not just an idea, but an expression of your idea. Examples, images, art, even programming is included under copyright. So if you have a game, this can be protected under copyright. There's a lot of artistic expressions that can be protected under copyright. Next slide. The copyright in China, although it's automatic in China, offers voluntary copyright registration, which provides proof of ownership. This is not a prerequisite to enforcing your copyright, but it will make the enforcement process much easier. And in order to register your copyright, it's a very easy process that can be done online. You don't need to go into the process of finding an agent like with patents and trademarks. So sometimes it's something that should be really considered by the SMEs in order to avoid future complications in cases. Next slide, please. Okay, so now we're going to discuss the trade secrets. Trade secrets in China are not simply something that you call a secret. In China, by definition, a trade secret is any non-public information with actual or potential commercial value, and that is guarded by confidentiality measures. So it must be something that you would really not want a competitor to have. Next slide, please. So the million-dollar question, when to make it a trade secret? Well, the difference between patent and trade secret is that the patent it's a maximum of 20 years of protection if it's an innovation patent. Trade secret is a protection until public knows how to do what you're keeping a secret. So it could be 20 years, it could be 50, but it also could be a year if the trade secret is very easy to be found out. So this is a decision for the SMEs to take, whether they want to patent their IP or keep it a secret. It's completely up to the company. We could help, again, to not hesitate to contact us. Next slide, please. So how to protect your trade secret if you choose to go this way? You need to put all the measures in place, or otherwise when you try to enforce your trade secret protection right, you will not be very successful. The measures are physical measures, so this is very simple, just like put keys to the doors or a code to the door, mark the documents that are confidential as such. Technical measures like separating manufacturing and assembling and distribution, so they don't know what the others are doing. Use special fonts like microtext because it cannot be photocopied. Next slide, please. And then, especially important, contractual measures. Keep it safe, keep it secret, keep it safe. Sign NDAs and NNS. And very, very importantly, train your personnel. You need to train your personnel to know what is a trade secret and how to keep it secret, because a secret is a secret until someone tells, and then it becomes public, so everyone in the company should be on the same page of how to keep a trade secret, and especially if they have access to it. Next slide, please. So this is applicable for all of your IPRs. What happens when there's an infringement? So first thing to know is that if you're collecting evidence, the evidence needs to be notarized by a Chinese notary public, or it would not be accepted by the court. This means that if you're in a trade fair and you see your product, your counterfeited product, taking a phone with your cell phone would not be enough as proof. You would need a Chinese notary public to go with you and take the pictures and notarize that these pictures are real. So that's a very important thing to take into account, to not spook the infringer by taking the pictures, and then those pictures cannot be used. Another choice you have for enforcement is negotiations. Licensing is always an option, and this means that sometimes it's easier to negotiate a licensing deal with the person that is infringing your rights than to actually go forward with the enforcement case in court. This is again a very personal decision of the SMEs, but it's being done quite often in China. And then when you want to go with all the guns, let's say, there are a couple of options in China. Next slide, please. So you have two choices. You have administrative enforcement and civil enforcement. Both have their pros and cons. Again, it really depends on the SME, the IP that you are trying to enforce. It really depends. So this is a very personal decision. Again, do not hesitate to contact us if you want to know more. Next slide, please. Okay, so what happens when the IP needs to be protected online? We've discussed copyright before, and it can be a very effective way of protecting your IP online. What happens very often in China is that these online companies like Taobao or Alibaba, the infringers put their products here, and they use the same picture to sell these fake products as the picture that was on the original seller and IP owner website. So if these pictures were taken from this original owner website, it can be alleged that they are infringing copyright, and it's sometimes faster to pursue this way than court one, because with this way you can use notice and takedown action with Taobao and Alibaba, and they will take the product down off the website before the infringer sells too many or any, depending on the moment that you have chosen that you have found them. Good thing to find these sorts of things is that if you are familiar with Taobao or Alibaba, there's a function of searching by a picture instead of searching by a word. So if you use your own pictures, it will come up the results. This is a very easy way of finding out if someone is infringing and using your picture. So next slide, please. As a general conclusion, register your IP as soon as possible. Do develop a strategy and a portfolio linked to your business plan. This is very important even if you're on the market for Chinese partners. They take SMEs very seriously if they have their IPs registered. Always sign NDAs and NNNs with partners, contractors, and with employees. And last but not least, contact us for help with your strategy or if you have any questions. Next slide, please. So just as a reminder, stay connected with us. We are a service that is free. We are confidential. We have been doing this since 2008. So we really have been helping a lot of SMEs. We know that we are dealing with SMEs, so we will not talk the law as if we were all PhDs in legal studies. We focus on business talk. And you can contact us on the email that you're seeing on your slide, question@china/IPR-helpdesk.eu, on the phone, on the website, on WeChat, everywhere in social media. And then lastly, thank you very much for your time. And please, if you have any questions, do not hesitate to ask me or to send me an email. Any of my colleagues as well. We are at your disposition. Thank you so much.
Thank you very much, Aida, for the excellent overview of the IPR situation and what the IPR help desk can help European organizations in China. We are running a bit late, but we still have time for a couple of questions. So if you have any question, you can put it in the platform, please. So we have here a question from Diego Samaritano, Project Officer from the European Commission. And the question is to Professor Huang. The access by foreign entities to Chinese patent application subsidies are the same rules as for Chinese entities? So basically the question is, any information that you could supply, Professor Huang, on access by foreign entities to Chinese patent application subsidies? And then if the rules are the same as for Chinese entities.
Thank you for the question. I know that what in some province, for example, cities like Shanghai, they also give subsidy to foreign company, but I have not verified that whether the foreign company receive the same amount of subsidy compared with Chinese company, or how the rule differs between them, or whether they're different. So I cannot answer exactly this question, but at least I know that foreign companies are able to receive subsidy. So I think for different provinces, different cities, the rules are different. In Shanghai, foreign company may be able to receive. I can confirm they can receive, but for the other province, I'm not sure. So I'm sorry, I cannot fully answer the question. I just know for some cities and provinces.
Thank you very much, Professor Huang. Then there is a question if the presentations will be shared afterwards. We are going to send all the presentations to all the participants. So we are also going to put the presentations under the ENRICH in China website. We have another question, this one coming from Lin Mei Ni. Is ENRICH Innovation Center willing to join some new Horizon 2020 proposals? So this is a very good question. In the future, we are going to be an independent legal entity. So we are going to establish a legal entity in China in beginning of 2019. And we also plan to establish a legal entity in Europe. Once we have the legal entity established, then ENRICH in China will be able also to apply to Horizon 2020 funding. We have another question coming also from Lin Mei Ni on patent registration and paper invention publication. Which should come first? I don't know if Professor Huang, you can answer this, or Aida, if you can answer.
Yeah, which should come first? No, not come first. It's an either or. It's either an invention, either a utility model, or a design patent. It depends on what you want to patent. It would be one or the other one.
Thank you very much. Aida? Are there more questions? I think I have answered all the questions that were put in the system. So I think it's time now to finish. So once again, I'd like to thank very much for the three speakers, for Jessie, Aida, and Huang for having agreed to be with us today. Thank you very much to the Diego Samaritan and Laurent Boscherot from the European Commission. Thank you very much for all the participants that joined us today, both from Europe, early morning, and from China, already late afternoon. We really appreciate, and we are going to keep you updated on the next activities and services of ENRICH in China. Again, thank you very much, and we stay in touch. Thank you. Bye-bye.
Thank you.
Thank you.
Thank you.